The core problem is cutting out competitive bidding because you're foreclosing out the opportunity to create equity.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Alan Friedman.
A portion of the Community Wealth Preservation Program, or the CWPP, has been ruled unconstitutional. Joining me to discuss this development is the author of the IL amicus brief, Friedman Vartolo partner, Catherine Aponte. All right, Kat, thanks for joining me today.
No problem.
For someone not familiar with the CWPP and what it required, can you just kind of walk us through what the constitutional challenge was?
The constitutional challenge was to the second right of refusal, subsection G, which allowed nonprofits to bid and basically take the property for the upset sale. When I say bid, it was just the upset sale. So there was no competitive bidding. They were just taking the property at what was listed by the foreclosing plaintiff as most usually their max bid, and then they would win the property.
A nonprofit was able to, in essence, win the property for plaintiff's upset bid.
Yes.
What was the core problem with that?
The core problem is cutting out competitive bidding because you're foreclosing out the opportunity to create equity. The equity would go to both the property owners and or any creditors in line after the foreclosing plaintiff.
So you submitted this amicus brief on behalf of the IL organization. Why is it important for IL and our firm and for you to do things like this?
On reviewing the CWPP as soon as it passed, there were glaring constitutional problems that would prevent our clients from being made whole if it were not challenged.
Practically speaking, what is now going to change?
So what's now going to change is that subsection G will no longer exist. Nonprofits won't have the ability to come in and exercise their right of refusal, thereby taking the property at plaintiff's upset.
Sheriffs must be happy about this.
It was confusing and hard to enforce, so there has to be some, sense of relief because their problems were defining what is a legitimate nonprofit, who can actually participate in this. There were a lot of questions surrounding that initially too.
Just a hard thing to enforce
Yeah.
and investigate. Looking forward, is there anything else big in New Jersey where an amicus brief might be required or something major could be coming down the pipe?
I think a challenge to the first right of refusal might be harder, but that is another avenue. And there are other provisions within the CWPP that could be challenged as well.
So we think if anything major occurs in Jersey, it's probably CWPP related.
Probably for right now.
Look, I think anytime you can do something right here, writing this amicus brief, where your efforts have such a big result and impact on the industry, you got to be pretty happy with yourself.
Yeah.
Thank you for joining Catherine Aponte and I in the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.